230 years and 1 day ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The third article was originally proposed as two separate provisions, the second of which read, in part, "The right of the people peaceably to assemble and consult for their common good shall not be infringed." The final phrasing dictated, in part, that Congress shall make no law abridging the right of the people peaceably to assemble. The right is referred to as the freedom of association in NAACP v. Alabama 1958, which ruled that the state of Alabama had violated both the due process provision of the 14th Amendment and the right to assemble provision of the First Amendment when the state issued a subpoena demanding the membership lists of the National Association for the Advancement of Colored People, because, as Associate Justice John Marshall Harlan II said, compelled disclosure of affiliation with groups engaged in advocacy may constitute as effective a restraint on freedom of association as the forms of governmental action in the cases above were thought likely to produce upon the particular constitutional rights there involved. Harlan further asserted that the inviolability of privacy in group association may in many circumstances be indispensable to preservation of freedom of association, particularly where a group espouses dissident beliefs, and compared Alabama's demand that the organization disclose the identity of its members to a requirement that adherents of particular religious faiths or political parties wear identifying armbands. The freedom of assembly is one of the three legs, along with the freedom of speech and the freedom to petition, upon which stands the right to protest, which is itself not separately listed as a right or freedom in the text of the Bill of Rights.